The ACLJ is going to the Supreme Court. We filed at the Supreme Court a huge new lawsuit that is going after, really, let's just say, reopening the idea that you don't get blanket essential immunity to say whatever you want, any lies you want to come up with, just because you're the news. Well, the ACLJ is representing a new client. This is Alan Dershowitz, who, again, this is going to be an interesting one. You've got Alan Dershowitz suing CNN with the ACLJ involved.
It goes to the heart of what is called the Sullivan decision, and that is a case that was decided back on March 9th of 1964 in the case New York Times v. Sullivan, which gave this higher protection to the media when it comes to defamation claims. The court found that you had to find actual malice by the individual, and it created almost an impossible standard for someone to address if they have been defamed. Now, what the ACLJ is doing here is kind of going to the court, because there are split decisions from appeals courts when it comes to where this could lie, and then also looking at the Sullivan decision to see if it needs to be re-examined altogether, since that was decided in 1964, and the landscape of media has changed quite a bit.
So much since the 60s. Obviously, when this was set in place, they had no idea what was coming, which would not only be 24-hour cable news, but then just around the corner from that would be the way they run social media and the way how mainstream news has certainly a big footprint in terms of getting messages out there in digital media. So I think it's time, whether you're actually for this or against this, and whether you like our stance in this or not, I think it is actually time for the court to weigh in and make some new adjustments to how this is being taken.
It's almost impenetrable. It really is impenetrable. If you're a public figure and the media attacks you, President Trump has seen this. It's basically, we tell clients, sorry, there's nothing really we can do. Now, what's interesting here is in Professor Dershowitz's case, which it's quite an honor for us to represent the leading constitutional law professor in American history. He was representing President Trump with me and Jordan at the Senate floor during the impeachment. And he made a statement of how the impeachment laws are supposed to work under the Constitution, what constitutes an impeachable offense. And CNN, after knowing exactly what he said, all their commentators went on, made up a thing called the Dershowitz doctrine, which there is none, and said completely the opposite of what he said. They had the tape, the whole world saw it, and they continued this for a couple of days. They never retracted it. So Professor Dershowitz filed a lawsuit. The judge said that if there was ever a case of defamation, this was it. But the only thing standing in the way between Professor Dershowitz and justice is a Supreme Court opinion called New York Times versus Sullivan, which was in 1964, which gave media heightened protection. But the media landscape was totally different then. Now you have everybody's media. So what you've got is, as you mentioned, this impenetrable wall. We're challenging New York Times versus Sullivan. We also believe that the burdens that they place on plaintiffs is outrageous in these kind of cases. And let me take it a step further. It's not just, how does this impact CNN? It impacts everybody. Because as Logan, as you said, these are calls we get, including from the president all the way to Professor Dershowitz, to other people. The attacks that come and nobody can take legal action. We're hoping to change that. Justice Thomas, Justice Alito, Justice Gorsuch have all questioned the law, saying it was created out as a political decision, not a legal one. It's not rooted in the Constitution. And we have filed the petition for certiorari. It has been filed as of about 45 minutes ago. So we are now officially at the Supreme Court of the United States. And what I think is probably it is one of our biggest cases we've ever had. The implications are huge. And our ACLJ members and donors have made this possible. And it was a lot of legal work. I'm excited, very pleased with the product. The other side gets to respond, then we'll respond again. And we'll probably know end of the spring if they're going to take it or not. If they do, we will argue it next year. I'm optimistic. There are justices calling for this decision to be overturned. It's time, and we're optimistic, and I think we've got the perfect case for it.
What New York Times versus Sullivan seems to have done is tip the scales in favor of the press to some degree, giving them an enhanced protection, while those that may be subject to not being able to address get a redress of their grievances by petitioning the government because the scales have been tipped for the press. Is that something that we're addressing here as well?
It's more than tipping the scale. It's pretty much eliminated the right to petition the government. By the way, the petition to government is not just a petition to Congress. That includes going to court because you can't win. The court here, the lower court, who ruled against Professor Dershowitz and said, we're ruling against Professor Dershowitz because New York Times versus Sullivan, even though they say, of course he didn't say what they said he said. Now, I mean, think about that for a moment. So the First Amendment is not a license for libel and slander. That was never the founders' intent. So they will still be First Amendment protections. You're going to have to show truth will always be a defense that the media can use, and that's fine. But this enhanced protection, and by the way, Alan Dershowitz, not only clerk for Justice Goldberg, who wrote a concurrence, he worked on that concurrence. But the concurrence was limited to not public figures, but public officials. And that was basically government figures. So it's got huge ramifications. It will be very helpful as we move forward with real freedom of speech and freedom of the press.
This is from a concurring opinion with the 11th Circuit, which was the appeals court that ruled against Mr. Dershowitz in this case. And this is from the concurring opinion because it's fascinating when you read it. This is from Judge Lagoa at the 11th Circuit. It says, as a preliminary matter, there can be little dispute that CNN defamed Alan Dershowitz under any common understanding of that term. So this judge is saying, no dispute. He was defamed by CNN. CNN, through its various writers and anchors, repeatedly misrepresented statements that Dershowitz made on the floor of the Senate. That is, statements whose accuracy could easily be verified against the Senate transcript and video footage, and which CNN employees all could have watched live. In some instances, they blurred the line between fact and commentary, and in others, they simply lied about what Dershowitz had said. This is coming from the judge. Skips down, goes through more facts in that, and then says, all of this to say, I agree with the district court that the only thing standing between Dershowitz and justice is Sullivan. And that is exactly why we are going to the Supreme Court, because as this lower court judge, the appeals court, said, our hands are kind of tied here because of Supreme Court precedent going back to 1964, which raises it, and as your dad said earlier, Logan, as you said, makes it impossible. This barrier, this wall is impenetrable because of the standard that Sullivan set. And so therefore, when you start thinking about who could be a public figure, who could be lied about by the media, it could at some point get to be everyone, and then there is no avenue under the Constitution to petition the government for the redress of your grievances, which is also guaranteed in the First Amendment.